Hi guys, it's Kathy. I hope you're doing well. We made it to Tuesday. Oof. That's way too close to Monday. Ugh. I hope you guys had a good day yesterday. I hope nobody is in jail. I hope Snoopy's surgery was okay. Or is it right now? Might be right now. I'm glad T's husband got home. Bren, I hope you're feeling better and not in too much pain. Alright, today we have a pro se guy who's trying estate law. We don't do estate law much here because I don't like it. I get bored. I watch the most boring stuff you can imagine with Glee every day. And I turn on estate law. It's like, the reason is I sort of like feel like I know the answer as soon as the case starts. I know you have to listen to all the evidence, but then I got to listen to all this evidence that means nothing. It doesn't help at all, and it's a lot, and it's every case. And when there's lawyers involved, it's even worse. They pull in all these laws that absolutely mean nothing, and then it turns out the way I thought it was going to turn out way at the beginning. So I get bored. But we're going to do one anyway because I want to make sure you guys get all kinds of stuff here. I don't like that. I'm not happy. Nope. I'm happy enough. Let's just press play.
Edward O'Hannesson versus Eder Ash and the Theodore Graber Trust.
We're on the record for cause number
O'Hannesson is a nice name. Yes, sir.
20D022510PL181. This is Edward David O'Hannesson versus the Theodore Graber Trust. Tina Eder, trustee. It says Brendan Ash, but he's been, I think he was dismissed already. So, as defendant. And then who do I have with us here today? For the plaintiff?
I'm sorry, sir, what?
You identify yourself for the record.
Oh, yeah, I'm Edward David O'Hannesson, and I'm the plaintiff.
Thank you. And then for the defense?
Attorney Thomas Tokar, and I have Ms. Tina Eder is appearing by WebEx on behalf of both herself as trustee and on behalf of the trust fund.
And we also have, though he's just watching, he's not a part of this, but he's more than welcome. The court-appointed personal representative, successor personal representative in the estate case, Attorney Matt Yakey. And you're welcome to speak up when it's your turn, Mr. Yakey. But I guess for now, Mr. O'Hannesson, since you're self-represented, can you raise your right hand for me? Do you affirm under penalties of perjury to tell the truth?
Oh, I do.
So I think, if I remember correctly, because this was from the 14th, so it was probably, this court date was probably like a couple days before the 14th. If I remember correctly, he has been living in this house for like 22 years or something like that, and now he has to leave.
Thank you. All right, so we're here for a status conference. Mr. Tucker, you filed a proposed complex pathway management order, which I appreciate. I guess, though, one of the things to discuss here is if the parties haven't been, if the defendant that's known to be left, that the Theodore Graber Trust has not been properly served, I don't know how we can, other than, anyway, that's off.
Well,
it's part of an issue, but why don't you go ahead and tell us where we're at with this case.
Thank you, Judge. There have been two major motions that have been. What we do have is that on Friday, March 6th, had filed the defendant's motion for the one significant trust in the home. There's a pending purchase agreement subject to your approval, Judge, for the home to be sold. And Tina is available here if there are questions. But what we've come to, Judge, for months and months, the trust has had no funds at all. Tina, from her own pocket, has been paying, and for the last 10 months or so, Tina has incurred 121,000 worth of expenses on.
Come on. Come on. Sir, none of us here are stupid. Not zero of us here are stupid. She's been paying out of pocket for 10 months for this house and has incurred $100,000 in debt. Shut up. Come on. V, nice. You changed your icon. Now no one's going to know who I'm speaking to when I say V. And I'm not going to stop saying V because that's your name.
Behalf of the trust and or estate, she can't continue to make the mortgage payment, which combined with the first and second are approximately $1,000 a month, plus all the maintenance and the utilities in the trust at all. And I had met prior to this hearing with the plaintiff to see if he would agree that the home be sold and have you, Judge, determine what happens with the proceeds. And he has no desire for the home to be sold until the case is completed. But I think it's doing a disservice to the trust to compel them to not just have a large monthly expense, but to have a vacant home that is quite likely deteriorating in value while we have a broker who's found someone prepared to pay $310,000 for the home. Between the first and second my mortgages, I've been told there's approximately $120K owed. So the estate, well, strike that. The trust would
Hold on.
have net.
Time out, sir. Time out. So in the last 10 months, paying the mortgages, she spent $100,000. There's 2 mortgages and there's $110,000 left owed on them. Yeah, that math absolutely checks out.
Proceeds, I believe, of approximately 170 to 175K, and we see no purpose for the trust to continue to be cash poor and have a home that does need to be sold. That is the one thing. And plus, if we could in the near future have a hearing to see if the trustee could indeed be repaid for what she has advanced the trust. And then Judge, not more troubling, but troubling to me is I've just been given a proposed motion for leave to do a third amended complaint. And I myself am disheartened to see that I'm being put back as a party defendant when I know that at two hearings ago, I believe with the agreement of the plaintiff, I, as the attorney for the defendant, had been dismissed from the case. And I don't want to say that I'm mad, Judge, but I'm not happy that apparently these tactics are continuing to be used. And I myself would strongly object to that third amended complaint.
He's calling the lawyer as a witness. Is what he's trying to do. So, I don't know. I guess I feel bad that he has to leave his house after all these years, but I don't 100% agree with him. Like, yeah, there's mortgages on your house. You didn't pay the mortgages, you gotta move. I think it was your wife that died, and the house isn't paid off, and you're not paying the mortgages, so you do have to move. That's how life works.
Being allowed to be filed, if that is what the plaintiff intends to do, to use strong arm tactics. The fact that he is not agreeing for the home to be sold, stating he can't pay for it, but that's not his problem at that point. And Judge, it seems it's approaching bad faith. And I myself would say if it continues, if perhaps this entire case should be dismissed with prejudice. Thank you, Judge.
All right, Mr. O'Hanson,
Yes.
we'll just start with just the basics. I mean, have you ever corrected the procedural defects that you had
Well,
before?
what I've done is, I've done the best I can,
Well,
and
the
I,
question is not the best you can, but have you corrected the defects? Whether or not you succeeded or not. Like, did you ever properly serve with the summons and complaint?
I thought I would handle that with the third amended verified complaint. So I wasn't sure that that was the way to go. But the problem is when you have been excluded from legal counsel that has the necessary expertise in a variety of areas, it doesn't matter how much I try, finding competent help or counsel is impossible. I don't have the money, and they don't. Oftentimes they don't have the expertise. So, but I guess that perhaps if you're willing to see what I filed, if I have corrected it, wonderful. If not, then I guess that's that. But I do want to address this idea of the trust having no money. I think that's I think that's a serious misrepresentation. And the reason I say that is because for months now, Brendan Aish, who had purchased the office building, has been providing $2,000 a month, which has not been in any way accounted for. There has been no accounting at all for the behavior of what the trustee is doing. And I mean, so I guess and that's why I was greatly encouraged when we had a personal representative, because he will have the authority to say, give me all of the information. Because so far, all I know is that my Social Security was taken and I wasn't reimbursed for it. I also know that $500, more than $500 was taken out of the trust account and put in the trustee's personal account. And so, as far as I know, there hasn't been the proper process and accounting. Now, they managed out using property law and did not address issues of trustee fiduciary responsibility to me as a.
That's all good. That's all fine. What he said is all fine and actually interesting, except the question was, sir, have you properly served the other party yet? That was the question.
Surviving spouse. That's why I have this book that I filed, and so I've got 15 exhibits, including one that talks about 5 chronological impossibilities.
Do it, Linus. Do it.
Of this whole thing.
No,
For
it's
example,
not.
we have
Fleischer had a sov sit today, yesterday, guys. Not on the menu today. Listen, a clip that runs today will not see my eyes for like 2 or 3 more days. I am 300 dockets behind right now. It's okay though. We're fine. We don't have to see it. All of us already saw it in bills.
we have a trust dated May the 6th, but the trust it's a 2-page document. And you take a look at another document that they provide, which is.
Finish that thought first. Okay, you take a look at the trust. We have a 2-page document. Now finish what you were going to say. You didn't say any. You're moving on to another document, sir.
A timeline concerning Theore's stuff.
I would never use Judge Fleischer. I won't put him in my thumbnail. I will put him in my descriptions. I won't put them in my titles. Maybe in a little bit I will. But he doesn't want fame right now, but he's streaming again. But it was really bad for him when he was very famous. So I'm tiptoeing around him right now just to give him breathing room to sort of, figure it out. I don't want to attract anything more to him right now yet. Soon. Maybe after November. After November. But right now, no, I'm hands off. I will show him abso-freaking-lutely at the end of my docket when no one knows.
The red truck got sold without any permission. They violated their own trust requirements, and so they may have been successful in using property law and ignoring issues like the duty of the trustee to a surviving spouse. They have tried to essentially take material from this trust and from that trust and cobble it together. And so far, they've been able to do this without any oversight. I would like to see them provide, for example, here they're hot to trot on selling this property for $310,000. But in fact, I looked up the value of it.
That was my grade school name.
And in fact, before I requested that the person representative put a halt to the sale because I had not been consulted at all. I don't know what they did with the furnishings. There's no accountability of any of it. They've made use of the car, but I do know that $10,000 has not been accounted for. And as far as I'm concerned, that's conversion. And I've added that in here. And I don't think Attorney Tokar should continue, since he now has been made, if in fact you will permit it to happen, he has been made a defendant as well. Now, when I did that before, it was a mistake. As a matter of fact, if you look that I filed against him specifically, all I did was I made a mistake in adding his name as a defendant. But the court has the complete authority and to do whatever they like. I have to say that I personally feel like I've been railroaded from the beginning, all because the trustee did not provide me any money at all during this entire period of time. So I've been living on my Social Security, paying $500 so I can have a room at someone's home. Now, they're very kind to me, and I'm very, very grateful for all of it.
Wait, you pay $500 for your room? Do you really? Interesting. Linus, if you want to see a clip, just say the word, boom, and I will show it. We are Court Vibes. I'll play anything you guys want me to play at any time, unless it's copyrighted. Everybody keeps sending me copyrighted stuff. I was demonetized once. 6 months, no pay. That would really hurt me. Oh, Jude, I know. Your brand new computer should be nice to you. Open ChatGPT and ask ChatGPT what to do, and you'll be all fine.
But the idea that after I've been, in my opinion, railroaded, kicked out of my home for 26 years, that there have been a variety of misrepresentations made with no answer. And while I'm talking about that, let me just mention, I fortunately have purchased the recording of the hearing in which the distinguished attorney accused me of somehow he had heard that I had somehow had difficulty with Judge Sparata And I said, well, let's call him in. But I have the recording. And I tell you, regardless of what this court decides, it's my intention to bring what I consider, what I understand is, I don't know if I'm even saying it correctly, the spoilage of trust documentation. I have a copy of, I don't know whether it was, I assume it was Tina that was speaking, but it was Bill's email, and it was sent to Attorney Tokar. Now, I don't know how I was able to view it, but I copied a single page. There were many pages to it, and I would like to see the rest of what that email has to say. So I'm a little raw, Your
So
Honor.
you're asking for attorney-client privilege communication that you somehow got
Well,
accidentally copied on?
no, I don't. I have the email here.
Let me ask you this, Mr. O'Hannison. Do you have, what are your allegations in your third complaint against Mr. Tokar? Is it just from him representing the trust?
No.
So you're saying he's more than, like, he's personally involved, that
what I'm really saying is
he's not doing his job as an attorney?
he went beyond advocacy. He went beyond advocacy in the things that he did, the things he accused me of, and his operation but I've got
I
it.
don't know if we need to get to that point. At this point, you don't even have, you're asking for a third amended complaint, which the rules say that you get one free bite of the apple before another party appears, but then another party could object. And so this is now complaint number 3, or is this
It's the,
Number 4, Your Honor.
number 4?
well, I mean,
And so then,
because of my old age, I
Yes.
lose track of count. I
but
thought
you
it was,
still even haven't served properly. I'm looking at the record, and Ms. Etter still hasn't, I mean, we have a December 15th.
Remember, that was the question. We just spent 17 and a half minutes wondering if this person has been properly served yet.
Attorney refused service as to the second amended complaint. I'm not sure if you've ever properly served Ms. Etter as trustee.
Lauren?
And so I guess then that leads me to this question, Mr. Tokar. If I were to rule on your motion, then you're coming to, that means you were consenting into this case. Ms. Etter is at least the trust, because I'm exercising power over an asset that the trust, allegedly owns. So that means I'm taking jurisdiction of it. Is that something you want me to do?
Judge, I'm sure you know more of all the consequences, but we, the defendants, have always accepted.
Hedwig. Listen, Hedwig. I don't know if you saw American Court Stream yesterday with Judge Fleischer, but whatever you do, do not read chat. It was brutal. We got Brennan there saying how childish Harry Potter is. Childish. Then we got Josh saying the movies are better than the books, Hedwig. It hurt. It was rough. I needed to wear a cup to make it through my chat yesterday. Whew.
Your jurisdiction of the subject matter case. We have just not had a proper complaint filed. If that means that if you would grant the motion for the sale of the home, then you would have deemed proper service on both the trust and the trustee as an alternative.
Well, I wouldn't do that, but I would deem that service is waived based on you filing that motion.
Well, would the fact that I have made an oral motion today being stunned that I'm back to being a defendant and that there is yet a third amended complaint, I would
But
say
you get time to respond to. I wouldn't. I mean, first of all, you've orally objected, but I would also give you an opportunity to a written response because it was just filed today. So you'd get
And
30 days. But I guess this is the question you need to ask. Because if the trust isn't a proper party yet, because they've not been properly served, which was part of the reason why I denied the motion to compel that was filed earlier, was because there wasn't proper service of the initial complaint or any of the complaints actually, which Mr. Anderson, you need to start with the complaints that have been previously filed and approved first. That's what you'd have to serve first with the summons and subpoena on Miss Etter to the trust, okay? So that's what you until you do that, they're not, but wait, because if they concede that they're in the case, then you don't have to do anything else because I need to get them their commitment one way or the other first, okay? So let me start with them.
Okay.
So if they're not a proper party to this case, then I don't know if I have any authority to do anything with regard to the sale of this property. Then the property can be sold because the trustee still is not controlled by this court.
Judge, that seems like.
So I guess that's what you need to decide. If you're filing a motion here for me to decide about this property, then that seems to me that you're waiving into this court, the trust. And so then I do have to decide what to do on this motion, which I'm gonna then again, Mr. Anderson, a chance to file a written response. So I guess that's the question is, what are we doing here?
Well, Judge, based on the clarification from the bench, we wish the home to be sold, and I would agree there hasn't been proper service and the trust has not been properly brought into the case. I would then recommend to the trustee she proceed with the sale since there is no
So is she going
prohibition.
to file a motion to withdraw the motion then?
Yes, Your Honor.
Okay. All right, so then I guess that gives you your answer, Mr. Anderson. What you're gonna need to do then is if you want this case, you want this court to have any authority related,
Too far.
then you're going to need to get service done with the actual summons and the initial service documents that you initially did on the attorneys, but on Miss Etter and as trustee of the trust. If you did it, you successfully did it for some of the parties, but not all the parties. So you need to do that for her too. Do you understand?
Well,
And Judge,
Go ahead.
if I may, one of the reasons I filed that motion on March 6th concerning the real property is that I was informed by the broker, Tony
Please,
Von
Attorney
Traeger, that
Crucio.
the title company, I believe it's Meridian Title, they are saying so long as there is a PL case, they are not going to allow to be sold. So if the court would indeed, due to all that's happened, dismiss the PL case, the home can be sold. If the court will not do so, it does the trust no real good to be told they can sell the home if the mere fact there is a PL case in this court right now, the home will not be sold.
Well, I don't have a motion to dismiss in front of me by the trust asking you to be dismissed from improper service under the trial rules. So without a written 12D motion that says we've never been properly served, we need it dismissed. Again, I can't act without a written motion, just like I can't act on Mr. Anderson's motion because she's not been properly served. I mean, I have Rule 12 for a reason, and it's about, like, if it were already filed today, we could have had a chance to have that dealt with, but here's, I guess this is my kicking the ball back over to the other side though. Mr. Anderson, I think you need to keep in mind that the trust and the estate are two different sets of things, right? And so the estate, it sounds like, we have Mr. Yagey here, it sounds like there's been some discussions, but they're two different compartments, they're not together. So to the extent that, and then at this point, the court can't muddle them together, they're their own separate things. Does that make sense?
yes, and I want to also say that based on my imperfect research, I think that there are such severe problems with the trust that in fact I don't think the trust can stand scrutiny. And
But
so
you've got to get service first before you can make those arguments. And and you still don't have service. And on top of that, I mean, you talk about attorneys. I guess I don't know what discussions you've had with attorneys, what they've had for you, if you've offered contingency fee agreements or whatever. But there's things that's also the court can't wait around. We're not going to wait around for whether or not you can find somebody. You might not be able to find somebody. I know, and there could be a lot of reasons for that. I don't know. But you got to first get service before you can move this lawsuit forward. You have to get service.
Let me, for my own edification, ask this question. Tina Etter is there and she's hearing all of it. At what point does that constitute service?
When you follow the trial rules and you complete what the rules say you need to do to start a lawsuit, which requires a summons and a subpoena, unless they agree to waive it, because right now they've not agreed to waive it. And that was the question I posed to them, was are they agreeing to waive service, which they can do. But they've not agreed to waive it.
All right.
So unless they agree to waive it, you need to provide her with the summons properly addressed to her,
Right.
and served to her as trustee of the trust, not her as an individual,
Okay. Now,
serving the trust,
is it acceptable?
along with the complaints that
Sir, you need to listen to what the judge is saying. Because he's about to dismiss this case. Because you have not served them yet. And it's been a long time.
have been filed today and approved, not the third one, because that would come later. But the complaints that have already been dealt with.
Okay, the one that
So the initial complaint and then the first two amendments.
so you're informing me that even the first PL filing was deficient, the one I did. But
We've replaced it. You have to go all the way back. And a party's entitled to due process rights and notice of everything of all the complaints filed against them. And so to be safe, and I'm not telling you what to do, but
No.
my recommendation is to be safe. I would, the recommendation is to provide them with all copies, because to me, that's giving somebody process.
Right. Right. In fact, I mean, now, since Attorney Tokar has entered his appearance, does that mean effectively that I can serve the summons for Tina to Attorney Tokar?
Well, I don't know if he's gone on the record agreeing that he'd accept it. So an attorney can do it, but usually the attorney has an agreement. Usually attorneys will either agree to it or not based on the discussions they've had with their clients. It's possible if he were to agree to accept summons that you could serve.
The last text message I sent to Bren was like, hey, can I borrow $20? But he never replied. So.
On him, but he'd have to agree.
Well, and
Again, we're back to the same issue where we're at currently, which is whether or not the trust wants it at this point or not. Because if they want it, then that's going to change the issue. Then we need to get to the next step, which is then how do we deal with the pending motions? Which it might be, Mr. Tokar. It is just if the title company needs the trust to resolve this, you might have to appear. But since both motions were filed on both sides on the 6th or the 9th, well, the proposed complex management order was filed on the 6th. And then the other motions were filed on the 9th, so today, I mean, either side should get a chance to respond. But I do recognize the timeliness of the issue. So I guess let's.
I had Mexican yesterday for lunch, and I have cotton candy grapes right in front of me right now. You guys, and then of course, I have chocolate for the later parts when you guys start talking about chocolate. I got coffee. I'm ready. I'm totally prepared for anything that you guys throw at me in chat today, unless you start talking like macaroni and cheese. I don't have the stuff to make it from scratch. I have a box, but I don't want that. Don't talk about macaroni and cheese. Everything else is fair game. I have it right here.
Thinking out loud, let me back this up a second. So, Mr. Tokar, do you want do you think by Friday that you could have a discussion with the trust to see if they're going to consent or not to waive service and summons?
I would certainly think so. And Judge, if you're saying you would be kind enough to hold a brief hearing on Friday,
And then, Mr. Johansson, do you think you could have a response by Friday to the motion to sell the property, like a written response for it?
Okay, we're almost through the service and the selling of the house. But remember, he amended the complaint. He wants to call the lawyer as a witness. Judge still has to deal with that part.
Some of your reasons?
Um,
I'm trying to
I know,
make sure that,
Judge,
I'm trying to get this
I
where the
know
parties can be heard.
Judge, I so appreciate your effort in dealing with someone who doesn't have the.
That'll give you a few days to get service too.
Oh, I know. And I appreciate it.
Unfortunately, my cotton candy grapes are huge. They just are. I got little ones. I don't probably because, you know, it's March. But normally they're big, way big. Everything is just way big here in America. We just can't eat normal food. But they're really good. They taste like cotton candy. They taste like sugar. I don't know how they do it. I don't know what makes them cotton candy grapes, but they are outstanding grapes. They're really so good.
I don't know. It's for me. You know, it would be like. I mean, there'd be many other examples, and you know basically what I'm saying. It's like you don't know anything about electricity, and you're supposed to rewire your house, or. I mean, 1,000 examples. It doesn't really matter.
I am never supposed to rewire my house. Look, I do a lot on my own. You know, garbage disposal, fixed it. I fix my own stuff. No, I would never rewire my house. I would hire an electrician. Plumbing, okay, yeah, I'll do carpentry. Sure, I'll try it. Painting, drywall, acoustical ceilings. I will do that. Rewire my house? No. No, I'm going to hire an electrician. And if I go to court, or I'm not going to lie, I'm probably going to try pro se. But if I'm going to court, I should get a lawyer.
And so I'm
No,
unfortunately
Bobby,
in
no.
a very hard place because I have no resources to gain legal help, and the complexity of the case is such that nobody wants it anyway. Apart from the whole issue of, I mean, like doctors hate to testify against other doctors and lawyers.
Oh, shut up. That's not what's happening here, sir. Pasta is actually so easy. I don't know why we don't all make our own pasta. It's not difficult. We can all do it. We should all just stop buying pasta this year and do what JK is doing. Because it's smart and it's delicious. And it tastes better.
Lawyers often just don't want to get involved in that stuff. It just isn't what they want. And yet here I am. Really. So basically, if you give me will they, okay, so you want me then to provide justification for why the place should not be sold?
No, I'm giving you a chance to file a response to their motion, but rather than waiting, because it's supposed to be sold by, right now, the trust would like to sell it, sounds like by March 27th, is that correct?
yes, Your Honor.
So in order to try to keep the sale date, if they have the opportunity to sell it, if you can get a response filed so we can resolve that issue before then, and I guess here's the deal, here's part of the thought, it's a double-edged sword for you, because if they agree to keep this motion in this court, and they agree to, that means they're agreeing to the jurisdiction of this court, they're agreeing that they have service, then they're in court, and that deals with the problem that you currently have. right? That deals with the problem of service.
Well, for me,
The other side of it though is then you're gonna have to deal with whatever decision I decide on the real estate, which I don't know enough at this point to decide. We're gonna have to hear that at a hearing. But I'll just tell you from past experience is that I'm inclined to,
Oh, oops, Bobby, I accidentally deleted your comment. How did my finger slipped, Bobby? I'm so sorry, Bobby.
if there is being depleted by monthly mortgage payments, I see it as a more practical solution as well. What's the best value we can get out of it for the parties and the beneficiaries? And then I typically approve those sales and then held a certain amount of money in dispute and trust where neither party can touch until the issue's resolved. So that's typically what I've done in past cases. It could be different in this case based on what we hear. It could be, but if we can get this moving forward, because what we need to do for you, for Ms. Etter, for everybody is just get this resolved.
yes, let me mention one other thing. There's always, one of the reasons the judge, and I understand it, it's okay, I'm not arguing, but he said that I could not afford the place. And at first glance, that seems obviously true, because I only get $1,000 a month Social Security. But the thing that I did not do a good job arguing, I didn't argue it at all, is that home has 7 bedrooms and 7 full baths, plus 2 additional half baths.
What?
Now, if I were to,
What did he say? That home has 7 bathrooms, 7 bedrooms, and 2 additional half bathrooms. What? And they owe $100,000 more on it. I have a suggestion, Judge. I shall take over the mortgage payments, and then you can just close these cases and send them all on their way.
if I had argued, if I lived there, and we can rent out 2 of the rooms at even $1,500 a month, we now are generating income to make the mortgage payment. And while I was there, I got the utility bill down to like $350. It had been up over like $1,500 because Theora wanted the pool warm so she wouldn't get leg cramps, and she wanted the hot tub going. Well, I took care of all of those things, and I got the bill down to $350, at least
Pool and a hot tub.
the 1 month I was there. So, you see, from my point of view, if they were, not that they're willing, because what they want is they want the money. They're not really concerned. Forgive me. Anyway.
Well, that's more on the merits. And as far as I'm concerned, the civil lawsuits, which this is, only involves money. That's what it's about for most issues.
Mhm.
That's what we're here for. We're not here. So regardless of how that gets determined, it's a financial issue, I'm not revisiting what another court did.
No, and nor would I want you to.
And I'm also not inclined to allow an attorney who has a pretty good reputation in this community to be brought into a lawsuit just by doing his job of representing his client. So that's going to have to be looked at. But I guess the bigger question is,
That was his throat slam for the calling the attorney as a witness. I'm not going to let an attorney who's just doing his job to be pulled in as a witness. Nope. You're not allowed to do that, sir.
if I give the parties till Friday to file written responses, so that's Friday the 13th, could we come back in, looks like the 17th, wide open.
I can't remember if they said how much this house is selling for.
Could we have, maybe,
I can't remember. They said something. It was like, what was it? They have an offer for like $270,000 or $430,000. It's one of those two, because I get court cases mixed up a little bit. Either or. How do you pay that little bit of money for a 7-bedroom house? How? This is Indiana. I'm thinking of moving, guys. Thinking of moving to Indiana. Here's what I'll do. I'll pack up all my animals and my kids. And then we'll just move in with Bobby for a little bit until we get enough money to buy a 7-bedroom home. And then, Bobby, you can move in with us to the 7-bedroom home because there's 7 bedrooms. Everybody can move in with us.
At some point on Tuesday, the 17th, to maybe set an hour for argument.
Well, Judge, I have an 8:30 criminal in Soup 4, a 9:30 and a 9:45 in Soup 6, and an all-day trial with Magistrate Centron starting at about that same time. So I would say I would love to be here the 17th, but
I would not want to get his trial because he takes a long time to finish the sentence. But even if I wanted to, I cannot because I don't get Magistrate Centron, which really sucks because what a great name, Centron.
I'm not sure how I'm going to handle the
What
schedule
about
that
the
I've got.
18th?
I have an 11 a.m. hearing, if we could do it in the afternoon or prior to 11.
For Thursday, the 19th, I only have 30 minutes of hearing so far. How's the Thursday look?
What time, Judge?
I only have 2 afternoon hearings right now, 1:30 and 1:45, and the rest of Thursday is open.
Judge, I am free to do
It's
what
fine,
you
Bobby.
find
Just
available.
breathe through
Mr.
it.
Johansson,
You'll be fine.
Thursday?
That's fine.
Thursday, the 19th.
The 19th.
So let's go with 2 o'clock. We'll give you an hour.
And at that, on the 19th, then we will be making oral arguments.
You're making arguments on the 2 motions that were filed for today. So one is your amended complaint. The other is the motion to sell the real estate.
And Judge, if I
Wait,
would,
wait. Didn't he just say he was going to withdraw that motion to sell the real estate because they were never properly served? Right? Judge. Never mind. It doesn't matter.
file a 12B6 motion to dismiss, would the court entertain that first on the 19th?
I mean, you can get it filed in the next day or two, so Mr. Johansson can have some time to see it before we get there. I will.
Thank you.
But you need to file it within the next 2 or 3 days.
I'll plan to have it filed by tomorrow, Tuesday.
We can
But then
get
I
a
guess
free
you
maid.
also have to consider whether
We can get a free maid. Listen, I know how to get a free maid. Think about it. It's a 7-bedroom house. We could just give a room to one person if they want to be the maid. You can live here for free if you just want to be the maid. You be the maid, and you can live here for free. And now we have a maid. Oh,
or not how you're going to handle that motion for leave to amend the motion for sale of property, though, because if you're having me rule on it, that's going to be complicated for a 12B.
I was thinking if we could take them in stages, if the court would first address the 12B6.
and then we all take a bill. That way, it would be cheap. It would be so cheap. One person, you get the electric bill, you get the internet, you get this, and then we only have one little bill to pay every month, one bill, and then that's it. We live like kings in Indiana.
And then depending on what the court determines, could then rule on the sale of the home if the court denies the 12B6. And then at that point, if the court does the 12B6, then the filed motion by the plaintiff to have leave to amend the complaint a third time would become moot, depending on what would happen.
Okay. Well, I'm not going to speculate on what is in front of me. So, but if you file it, we'll figure it out.
Thank you, Your Honor.
All right. So
I'm always cooking. She will have food.
So I guess be on the lookout for that, Mr. Hannison, if he files any further motion.
See, this is, you know,
They can DoorDash for extra money.
I'll be on the lookout for it. I don't even know what I'm looking.
Well, but you know what you need to do. I mean, you need to, I mean, we've talked plenty about where you're at in this, so, and I don't think I need to revisit it.
Right.
So with that said, I'm gonna file whatever you need to file by Friday, and then on the 19th, I'll see you at 2:00 for a 1-hour hearing, and I'll hear her merits. Okay?
Thank you. And Judge, may the trustee appear by WebEx on Friday?
I mean, are you gonna need any testimony from her?
I am not aiding, but just in case.
If you're gonna talk about the sale of the real estate, you might need her. So I guess it's okay, but I need to be able to see her like I can today. And Ms. Edders, make sure your webcam and microphone work. Can you hear me today? Can you say something so I can? You're on mute.
Yes, I can hear you.
Okay. All right. So yeah, if I allow you WebEx, which I'll allow you WebEx, it's fine. But you'll need to appear like today, where I can hear you and take your oath and all the fun stuff.
Yes, solar and a goat. Oh gosh,
Okay.
please let us get
Anything else?
goats, guys.
No, thank you, Your Honor.
Anything else, Mr. Johansson?
I'm gonna put little skirts
No,
on the
Your
goats.
Thank you, Mr. Yankee.
Little
Anything
goat
on
dresses.
the estate side? I mean, I guess I'm not expecting you to say anything. Just you know what's going on now.
I know what's going on, and this was illuminating today, Your Honor. And I've looked over a bunch of documents. I have
Illuminating.
I'm working through a couple pathways that I might be able to try to broach a resolution in the estate. I can just tell the court that, tell Mr. Johansson and Mr. Tokar that today.
Okay. All right. Thank you. Thank you.
Thank you. Thank you. Well, that's what happens when you're pro se. Now, let me find. Judge Fleischer from today or from yesterday. Unless you haven't gone to bed yet, then it's still from today.
Any priors? Nice haircut. No priors, okay. Miss Welsh, come up.
Okay, that sounds weird. Hold on. Oh, the speed
Good morning,
is.
ma'am.
I'm gonna
Ma'am,
fix
as a
it.
condition of your bond, I'm ordering you not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly
Oh, that's
test
so
you.
funny.
If I find that you're using
Why? If I change
any
the speed,
priors,
it starts
Nice haircut.
over again. Why?
um,
That was cool though.
no priors, okay. Miss Welsh, come up.
We are absolutely going to do a
Good morning, ma'am.
Judge Fleischer
Ma'am,
on 1.25 speed one day because that was so cool. That was at 110%.
as a condition of your bond, I'm ordering you not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're using alcohol or illegal drugs, I will revoke your bond and put you in jail. No more PR bonds for you. Do you understand, ma'am? License?
Eligible, Your Honor.
Great. You're not allowed to drive unless you have a valid license. You must also maintain liability insurance in your name.
I will shut my channel
Because
down
you have
before
a
I make
lawyer,
fun of
will
him.
waive your appearance.
I
You don't
just
have to
would
waste
shut
your
my
time
whole
coming to
channel
court,
down.
but you must stay in touch, Mr. Sturgeon. He'll tell you if and when you have to come back to court. If he tells me he cannot get a hold of you, I will revoke your bond. So just stay in touch with him and he'll tell you. For now, we'll just have you sign a reset. You'll sign conditions, then you're out of here. Okay? Take care, guys. You too. Take.
All right, Judge, bottom of the page, oh, sorry, top of page 2. Badalamante.
Okay.
The angel's back.
Hey, morning. So where is this theft from? Please.
It's probably a Vape City retail vape store.
Got it. Okay. Let me see if this is crap. The wrong one. Yeah. Look.
That's his son,
You did
Alex.
one. Do all of them. Why don't you just did it you? Come on. Don't be lazy. Okay, you need to do more than that. All right. Sir, as a condition of your bond, I'm ordering you not to go back to this location. If I find that you do, if you pick up a new case, I will revoke your bond and put you in jail. No more PR bonds. Do you understand, sir? Okay, do you mind filing those conditions, please?
Yes,
Do you have the ability to hire a lawyer? Do you have the ability to hire a lawyer?
I do, yeah,
Are you working at this time?
yes.
Okay. So we will give you time. I'm going to have you go to Victoria Center Reset. I'm going to have you take your seat in jury box while we get your bond conditions. Once you sign them, at that point, you'll be free to go. You are not to go back to this location. Do you understand?
Yeah.
Okay, come on.
All right, Judge, top of 20. Gardens of Falls.
Good morning, ma'am. Ma'am, as a condition of any prior criminal history,
Checking out, no,
license,
we're already getting out.
please. Ma'am, as a condition of your bond, or you're charged with driving while intoxicated, you're facing up to 6 months in jail and or a $2,000 fine. As a condition of your bond, I'm ordering you not to consume alcohol or illegal drugs. You will be randomly tested. If I find that you're using, I will put you in jail. No more PR bonds. Do you understand, ma'am?
License is illegal.
Okay, you're not allowed to drive unless you have a valid license. You must also maintain liability insurance in your name. If you don't have liability insurance, likewise, you do not drive. I'm gonna have you, or do you have the ability to hire a lawyer? Sure, we'll give you time. Just don't wait too long. Timing is of an issue in this types of case. I'll have you sign a reset. You'll get with Veronica for your bond conditions. Then after that, you'll be free to go, ma'am. Please.
He's gonna fire Victoria and move Alex into that seat. Then he doesn't have to give them raises.
Bottom of 21, Martinez, come on up.
Ma'am, you are charged with driving while intoxicated. As a condition of your bond, I'm ordering you not to consume alcohol or illegal drugs. You will be randomly tested because you had one dismissed not too long ago. I'm now ordering you not to drive any vehicle that's not equipped with an ignition interlock. If you're caught driving a vehicle that doesn't have an interlock, I will revoke your bond and put you in jail. I'm sending notice to DPS in Austin so that every police officer in this state knows if you're caught driving a vehicle, that vehicle doesn't have an interlock, they're going to take you to jail. Do you understand? I don't care what you have to do. I don't care where you have to go. You cannot justify driving a car without an interlock for any reason. Do you have the ability to hire a lawyer?
No,
What do you do for a living?
I'm a open hygienist,
Okay, and how much money do you make a month, man?
about 3,000.
Are you married?
No, I'm single.
How many children do you have?
I have one child.
Okay. Deputy Chigon will give you an application. I need to know everything about you, whether you have any other sources of income, how much money you have in the bank, what kind of car you drive, how many cars, stocks, bonds, mutual funds, IRAs. I'll take a look to see whether you qualify.
Okay.
You're going to sign a reset. We'll get you with your conditions. Do not drive without an analog. Do you understand? Okay.
All right, Judge, top of 31, Vance.
It looks like I'm gonna do probable cause on this one. He's got some significant history. Mr. Vance, you're charged with terroristic threat of a family or household member. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On June 13th, 2024, officer was dispatched to an address. Upon arrival, he spoke with complainant, who advised the defendant, her husband, had called her on the phone and said he was on his way home and told her, "I'm gonna kill you, bitch." The complainant reported that she was in fear of her life and advised that she wanted to protect her.
So he has a prior BPO, assault, mischief, interference. Do any of these relate to the same complaining witness?
The same complainant on the BPO, the mischief, the AFM, and the
All of them.
same complainant.
I'm placing on you a magistrate's order for emergency protection. This is a court order that identifies Ms. Vance as a protected individual. You cannot commit family violence or an assault against this person. If you do,
Yo, if I could take my kids to work, they'd be rolling a heck of a lot of silverware. Yes, they would. Hurry up. Go take this to table 4. Hurry up. Go get those dishes off table 2. Hurry up. Hurry up. Go faster.
then you're in violation of this order. The state can and will file a violation of a protective order against you. That is the capital murder of misdemeanors. Do you understand, Mr. Vance?
My kids couldn't do it. My job. Nope. Not it. They couldn't do this and they couldn't serve. They just couldn't. Nope. Now, that being said, my daughter is a server and she's doing so well that she's the owner is talking about making her a manager. So she's a very good server, absolutely. But I don't think she could do my job where I work. Nope.
When I mean no contact, I mean no contact at all. Use of third parties, social media, text messaging, phone calls, anything. You will also get a monitor on your ankle so I know where you are, and you're not to go within 200 feet of where she lives or where she works. Do you understand? We are going to reset your case to give you time to hire a lawyer. So I will have you go to Victoria Center Reset. You'll get with Veronica for your bond conditions, and after that, you'll be free to go. Okay? Shoot.
We should learn smoke
Sure.
signals.
I'm not going to
learn
talk
that.
about the case. You have the right to remain silent. Exercise that right, because whatever you say, they're going to, use it against you to prove your guilt. So it's probably not a good idea to talk about the case. You need to hire a lawyer, and the lawyer can, advise you on how to go forward. Please.
Mr. James.
His son is under the desk. So, Linus, Eileen, the Sav sit was like in the first 40 minutes, correct? Right? I'm pretty sure, right?
Okay. That law is in your PJ.
Thank you so much.
All right, page 33, Judge Williams,
Okay.
come on up. Go ahead and sign for your reset. Have a signature box.
So if she's
Did
from
you say
Australia,
upper
then
30th
she
Street?
knows Thor.
Or bottom?
Margaret, do you know Thor?
Mr. Williams, do you have a lawyer today? What do you have the ability to hire a lawyer? What do you do for a living? You're a welder. How much money do you make a month? Welders make a lot of money.
Imaginary.
Sorry?
That's imaginary.
What's imaginary? Okay, and that doesn't sound imaginary to me.
Judge Fleischer controls the camera.
In a manner of speaking, when we're on the record, it's a
This is the sob sit, guys. This is it.
court of record.
For the record, state that I reserve all my rights for UCC 1-308,
Okay,
and I don't waive that never.
okay, great. But you need a lawyer to represent you. You're charged with driving while your license is suspended.
I object, Your Honor. I was exercising my amendment rights to travel.
Okay, well, you still need a license to travel, to convey, to drive,
License
to,
transfers my rights to privileges. I am not a 14th Amendment citizen. I'm American
well,
citizen.
how does that apply if you try to reserve all your rights and now you're not a 14th Amendment citizen?
Exactly.
Those are two contrary to each other.
No.
Sure they are.
Before the ratification, my rights is reserved before they were usurped to be privileges and for the state, which is a fictitious entity, and I being a common man of natural law, natural law, does not have jurisdiction to choose to make me pay any fines or criminal or anything like that. When I am exercising my right as a human, as a man, common law.
Okay.
So I brought my affidavit of fact to be filed to dismiss this case and have all the stenography conveyed to me. Deprived for 18 USC to 41 and 242. Return to the defendant, Andrew Morgan.
So,
So that Andrew Morgan Williams can go about his private life and his, also his right to liberty, freedom, and justice.
great. So, Mr. Williams, does Mr. Williams have a license to drive?
I object, a license does not make me applicable to travel.
Okay, you can object. And it will be duly noted, but as a condition of your bond, I'm ordering you not to drive if you don't have a valid license and insurance in your name. I'm well within my right to place those restrictions on you. So if
I
you
object.
you can,
Okay.
but I'm still
Does
placing
your-
them on you.
Does your delegation come from Congress?
Okay,
Does your delegation of authority come from Congress?
okay. I'm placing on you now these conditions. Please do not drive. If I find that you do, Mr. Williams, I will revoke your bond and I'm going to put you in jail. I understand that you would object to that, but I'm still within my right to do that. So if you want to drive, you need a license, you need insurance, and then I will happily take this restriction off.
Defendant Andrew Morgan Williams did in fact have the document that you required him to have, and whatever reason,
Oh, hold on. Does Mr. Williams have a license to drive? Hey, you are Mr. Williams, correct? So are you not Mr. Williams then?
I am Andrew Morgan Williams, not
Okay.
a fictitious
So-
entity. I am the living, breathing man.
Great.
On this jacket?
Hold on. Look, I've got a bunch of work to do. I have a ton of people that I still need to talk to. So I'm happy to, if you want to, I'll talk to you. Let me smooth everything out with everybody else, and then I'm happy to talk to you more. But I'm going to place this restriction on you regardless. It's what I do on every person when they're charged with a suspended license case. We just ask, order them, please do not drive unless you have a license. They've checked you in the DPS system. The system shows that your license is not eligible, so you're not allowed to drive. You're not allowed to convey. You're not allowed to travel by means of driving a car. If you want to take the Dodge Patas anywhere, you can do that. You can be a passenger in a car, but don't
Dodge
drive a car.
Patas.
If you do, I will revoke your bond and put you in jail.
My consumer goods, which I locomote and move, is not what your definition of.
You can try to justify however you want. Really, you can, and but at the end of the day, if I find that you drive, it's just really not going to go well. That's it. I have a lot of people that try to use the same verbiage, the same justification, but at the end of the day, if you're in a car, you're driving, whether it's for commercial, whether it's for residential, whether it's for personal, whether it's for private, whether it's for going to see Bambi or whatever it may be, you're still under the jurisdiction of the laws of the state, of the county, and I'm asking you, please don't drive. You need a lawyer to represent you, unless you want to choose to represent yourself, which you can always do. So if you want to do that, I have to have what's called a FRERETA hearing. So if you want to give me a little bit of time, let me talk to other people. I've got a lot of bond violations. Sorry?
I need to get to work.
Okay, just do not drive.
Can I have the?
Do you understand?
Stenography?
I right now appreciate every single one of my coworkers so much because my coworkers are not subsets that I know of.
Records conveyed to me, please, pertaining to this case.
I don't have any stenographic records pertaining to this case.
Is there? Is it not a court of record then? It's operating under the color of law.
Do you mind filing those conditions, please?
Yes, there's.
This is an affidavit that you're going to promise me today that you're not going to drive, Mr. Williams. If you do, like I said, I will revoke your bond and put you in jail. We will give you time to either hire a lawyer. If you'd like to, you can also represent yourself. But like I said, we have to have a hearing to see whether you should. Just because you can doesn't mean you should, as with everything in life. So let me have you sign this promise. I'm going to have you take a seat and.
So that's what I've been doing
We're having
wrong
a room.
with my
Right.
life.
I'm going to have bond conditions created for you to sign. Once you sign, at that point, you'll be free to go. Okay?
Right.
Please. So no driving without valid license and insurance. Hi. Hey, Mark.
Monica,
Just the
thanks
last name
for
of your
the
client.
cheers. Thank you.
Is, okay,
So Judge, we were here a couple weeks ago, it came back with a presumptive positive for THC. You said to reset it to today so she could go and retest. She's in the jury box, Your Honor, so just trying to see if we can send her over for that test.
yeah, for sure. Okay,
And
for it.
if it comes back negative, does she have to come back here?
no,
Okay, perfect.
No.
Thank you.
okay,
May I?
Hi.
More out of the box.
of course.
You'll have to file this direct for an attorney to file. Some of this for with information that you provided is not administered.
I just think my favorite way to handle a subset out of all the ways is when they say they're not that person, kick them out of the courtroom, put a warrant out for that person. That's just my favorite way to do it.
Yeah, yeah.
I guess my dad.
Hey, how are you?
I'm here, Mr. Frazier.
It seems that like every time we try to,
We have the same issue. There's
Still outside of the 200 foot range. Same thing as last time.
Say it again?
It's the same issue as the last hearing, in which there's no sort of evidence presented that he was actually within 200 feet of the exclusion zone.
Hey, Veronica, was he within the 200 feet or no? Raise your.
Judge, I'm just looking off the.
Why are they sending BVRs if he's not within? I don't understand.
I think it's almost just device dings. It's just does, but it's not within 200.
It's not supposed to if you're not in,
I
you
think
know, if
with
you're
us
compliant.
amending the exclusion zone to 200 feet, I'm not sure that it goes off when it's supposed to every time, but
Or,
Same.
I mean, let's see. They
it's the same
can,
location as it was at the last hearing.
So he enters the zone on 11:43 and then exits it 11:45, so it was only there, like within the zone for 2 minutes.
how far in?
If it's anything, so I could record that.
Judge, just going off the email that pre-trial provided that said that he was at the same location where he was alleged to have been.
I understand the location, but we tried to accommodate you guys. We asked you, what is the appropriate feet, you know?
Judge, I say that to say that location is not within 200 feet.
I want a
That's the same
huggy
guidelines.
jacket, please.
We've been here. This
So
is
you're telling me it's outside of the 200 feet?
yes, sir.
She's saying that he went in the exclusion zone.
I understand that. My point is that they are just assuming that the device dings every time it's within 200 feet. It does not. We did this last time.
To check it out, look at the map which she has. It should show exactly where he goes. If he
Right
goes
next to the
within.
car wash is 250 feet from the rest from the place.
I don't understand.
Zero.
Mr. Haynes?
Council, what is that? Yes. Yes.
So.
This is the cat that made me fall down the steps because he's solid muscle. He's so heavy. He's just solid muscle. Thank you, V. Thank you. Yes. I can see that this is not going to let me fast forward. I'm going to try. It's not going to let me. No.
Any priors?
And it
Nice
started
haircut.
over again, and I can't. There's nothing I can do about it. Everything I click is not working. Oof! Because I didn't get this
Any
clip ready.
priors? Nice haircut.
I just played it raw, but that's all right. I got 2 more clips. 2 more. Kelly, thank you so much. Thank you. Okay. Judge Link. I really, really, really love Judge Link. Oh, Kelly, thank you for the kitty fund. I'm not spending that money on him. Okay, I am. I just am. Oh, I gotta change the size. I'm gonna pause it. Because I wanted to make Judge Fleischer big. So I did. There we go.
The house. We both own the house, but I paid the majority, 80% of all the bills I paid. Our son lives, we have been broken up for 5 years, but she had moved out, but she came into financial trouble, so she moved it back in last summer with me. She had a falling out with the friend she was living with, but we haven't resolved that.
This judge, when he is on point, is the scariest judge that I've encountered. I've only seen him do it one time, but he's really good when he is angry. Kelly, thank you so much. We really do have the best chat. We just do. What videos?
House yet.
Well, this is a problem, Mr. Hollinger. The state, and I know it's not part of your plea agreement, so that's why I'm not able to accept this today, but it sounds like the state wants to make the no contact order part of the plea agreement, which means it would continue for basically 360 days while you're on probation. So that would prevent you from going home if Miss Childers remains living there.
Well, how are we gonna resolve our house, if I can't go back there?
Well, you're gonna need to go to court to do that. If you both are on the title to the house, then you're gonna have to resolve that in civil court. Because this certainly isn't working out for you. Based on what's alleged in the police report. So I think you need to talk to your attorneys about what your options are here and figure this out before you go into this plea agreement, because if you accept the plea agreement today, that term is going to be added.
Yes, the only reason I was going to accept the plea was because of, I was hoping I would be able to go home.
Well, there's consequences for that if that is part of the plea, which is preventing you. So, Mr. Walton,
Your Honor,
how long do you think it's going to take?
I'm not positive how long this could take. Do you think we could continue the
Thank you, Eileen. Thank you.
matter to April 6th?
All right, I'm going to give all the paperwork back to you, Mr. Walton. So that doesn't get almost.
Thank you.
Welcome matter is reset to April 6th, 2026 at 12:45 p.m. on defendant's motion, time charged to defendant. Now, Mr. Hollinger.
So he didn't take the plea because he can't get to go home. He still can't. He's still not allowed to go home though.
You reach an agreement that you want to accept before that date, you can ask your attorneys to move it up. Okay.
What's the date? April 6th?
April 6th. All right, you're free to go.
Thank you, Your Honor.
You're welcome. Stay.
He's going home. He's going right home because he didn't understand any of that. He didn't understand any of that from what he said. Okay, now we got one more tiny clip, guys. Just one more tiny clip. The pro se toilet paper guy. Here we go.
I've seen the blue chair.
Blue chair.
Start this. Hi.
Even the judge is wearing orange today, and it's all for Lena Thor. How are you? Boundaries are overrated. I wouldn't know. I just wouldn't know.
Good morning.
Who's in charge?
My name is
Probably
Ray
Kelly.
Hauser. Okay, it's 2603 CM63.
I think Kelly might be in charge here if I had a guess. Yep.
37, State v. Race Hauser is here today via Zoom from the Montgomery County Jail. So we're set today for an initial hearing. First, I've got a mailing. I guess what is a good mailing address for you, sir?
I just barely have been getting reestablished here. I don't exactly know my parents' mailing address. I'm not gonna lie to you. And even my ID, my driver's license is not up to date. Right before I came into here, I was in the Social Security offices trying to get my license established to be here.
Okay.
In Montgomery County.
There was a pretrial assessment we had done that listed 5.
Can you say that again?
5.
That sounds right.
Okay.
Yeah.
So what's that as your address? Its phone number ended in 2872.
Should be. My phone's been dead. And
is there an email address?
I can prove I'm not in charge here because none of us are incarcerated. If I was in charge, if I was able to rule, we would probably be incarcerated, all of us. But maybe in the same prison. That would be really cool.
Yes, there's also another email you may use.
What's that?
It's more professional.
All right. So you've been charged with 1 count of resisting law enforcement as a Class A misdemeanor, where the state alleges that on about March 9th of this year in Montgomery County, state of Indiana, you did knowingly or intentionally forcibly resist, obstruct, or interfere with Matthew Roberts, Montgomery County Sheriff's Office, a law enforcement officer, while that officer was lawfully engaged in his duties as a law enforcement officer, to wit, forcibly resisted being handcuffed by Deputy Roberts. Class A misdemeanor carries with it a penalty from 0 to 365 days, Montgomery County Jail, and a fine of up to $5,000. Do you understand the allegations against you and the possible penalties?
I understand the allegations against me and the possible penalties.
I would, but I might break a nail. So, that unless they stop at McDonald's, are they going to stop at McDonald's for breakfast? Then I will.
All right. So you also have certain constitutional rights. You have the right to a public and speedy trial by jury. You have the right to be presumed innocent unless and until the state proves your guilt beyond a reasonable doubt. You have the right to confront and cross-examine any witnesses against you. You have the right to have witnesses come into court, testify on your behalf. You have the right against self-incrimination, and you have the right to appeal your conviction if found guilty. Do you understand you have all those rights?
Yes, sir.
And you also have the right to be represented by an attorney. And if you can't afford one, the court can consider appointing one for you. Do you plan on hiring an attorney?
I'm going to represent myself.
Because you don't want the court to consider appointing one for you?
No, that's okay.
He needs to sit back. He is making me outstandingly uncomfortable and a little nauseous.
I would rather not create more work for the system than has to be made. And I apologize if I'm looking funny. I don't have my glasses on. I haven't been allowed them. This is a piece of paper. The last 9 days I've been able to get for notes. So here's my toilet paper roll for court that I have today.
Okay.
And, it's been really tragic. But from moving forward, obviously.
All right. So the court is going to enter a plea of not guilty on your behalf. We're going to set this for a pretrial conference.
You know what we don't have enough of? Finger Jello. We have plenty of Jello, but not enough. When I was growing up, there was always finger Jello at like barbecues, and they don't really do that anymore, and that's not fair. We need more finger Jello.
Say May 4th at 9 a.m. I think currently you're being held on a $1,000 cash bond. What was that?
Could you repeat that real quick? So
May 4th at 9 a.m.
May
4th, epic day. Yeah. So finger Jello is, you know how you can't really eat Jello with your fingers, regular Jello, because it's so, Jello shots, though, that's another story. T is speaking my language. Finger Jello, you put, I can't remember what it is. You put it in the Jello, and then you can cut them into little squares, and you can actually just pick them up and eat them. The word for it is right at the back of my mind, and it's not coming out. But you put this stuff in it so that it makes it more firm, so that you can just pick them up, little finger Jellos. Jello shots, though, I don't think it's not gelatin. You put something in the gelatin. to make it more firm. They're really great. They're absolutely great. But Jell-O shots, I have not been able to. No, it's not less water. There is a powder that you put in the mix when you're making the Jell-O. There is a thing, an item. You know, this a couple days ago, I was driving my daughter to work, and no, it's not just Jell-O. There's trust me, I swear that I used to make it. There's an item. I don't think it's gelatin. I just don't. I think it's something. Pectin. That's not right. That's not right. Anyway. Listen to this, guys. This is bothering me. Another thing that I was driving my daughter to work, and they had this thing on the radio. No, Lafayette. No. Try to be the smartest. Stop. Try to be the smartest listener. So they asked this question. Knox. That might be it. You might be right. Okay, Crystal is right, and I am wrong. So whenever Crystal speaks, and I'm arguing with Crystal, now you know whose side to jump on right away. So, NT. So, okay, what is this item that you have in your house that if you use, ouch, will make your toilets shinier? Okay, it's not a liquid. Do not hit me with toothpaste. Do not hit me with vinegar. It's not a powder. Do not go with the baking soda. Do not. It's an item that you have in your house that if you use while cleaning your toilets will make them extra shiny, which I think is bull. I just think it's bull, but stay with me. It is in your house. It's in everybody's house right now. I don't think there's a house that doesn't have it in it right now. You don't go out and you buy this. It's possible to go out and buy this, but nobody buys this unless you want a lot. It's already in your house. You don't have to buy it. It's already there. So it's not a powder. It's not a liquid. It's a thing. No, that would be a liquid. And it's not a cleaner. It's not a powder. It's not air. So I'm driving my daughter to work and back, and I am like completely flabbergasted about what in the heck this item could be. That it's not a vegetable, it's not a mineral, it's not, I mean, granted, we were the closest so far with air, but it's not air. And then they gave me the answer, which, no, I love magic erasers, T. I do love magic erasers. I'm very obsessed with them. It's not. I don't think I've ever used a magic eraser inside my toilet before. I know. It's not a toothbrush. And it's not your partner's toothbrush when you're angry. No, it's not soda, Coke, good one, but no, it's not a stone, it's not a pumice stone. Here's what they said. No, it's not vinegar because that's a liquid. With no liquids. Here's what they said, and it's been bothering me because I use this object to clean coffee, to the glass part of the coffee pots with salt. I use this object with salt in my coffee pot to clean it really well after I use it, but not in my toilet. And I just don't think it works. I do not. It's ice. Who puts ice in their toilet to clean it? Name one person in the history of the world that puts ice in their toilet to clean it. Ice. They say if you put ice in the toilet, the gel that's supposed to stick to clean it sticks better. No, it doesn't. I don't suggest putting pennies in your toilet. Since they don't make them anymore. Ice. I am never going to put ice in my toilet. No. It's not going to make anything more shiny. I just have issues with this question because, you know, I was racking my brains trying to figure it out. I said everything you guys said. Aluminum foil. I said all that stuff. A dryer sheet. You said iced tea. Iced tea. You said iced tea? Yeah, we don't put iced tea. Drink iced tea. Oh, Eileen. We are a bad influence on Eileen. Yeah, it sounds like one of those things that people say. People who have never cleaned a house before in their entire life say because they think it's a really good idea. Oh, we're going to put ice in here. It's really going to make their toilet shine. We should write a paper on this or put it on the internet. 10 things you should do in your house. So, yeah, that's what it reminded me of. Sorry, I'm going to press play again. We just went totally off on a side. That's fine. It happens. Dryer sheets are really, really good for... That's right, Kelly. I love using dryer sheets, too. Yeah, ice is great for coffee stains on coffee pots. Ice and salt and just a tiny bit of water. And you just shake it, and it comes out beautifully. But you can't really shake a toilet. And even... Okay, let's follow this through. You put the ice in the toilet. You squirt your little gel on. Okay? What is the ice supposed to do? Are you supposed to... Okay, even if you get a brush and you start scrubbing the toilet, what is the ice supposed to do? What is the ice doing? It's not like scrubbing. The ice doesn't scrub against the toilet. It just makes the water colder. I mean, I don't understand physically how does this work? How does ice make a toilet sparkle? The ice doesn't get up any higher to clean anything. Maybe this is as far as I'll go. Maybe when you flush and the water's swirling, the little ice cubes hit the bowl as they swirl and leave. Okay, I've cleaned a ton of toilets, and being hit with an ice cube once but on your way out is not going to clean anything. T, I'm so sorry. It does. They did say that it keeps the gel in there longer, but it only keeps the gel in that spot. Like the gel going up the side is not getting thicker or doing it. The ice isn't doing anything. Maybe, Bobby, maybe it acts as an abrasive, but only for one swirl. That's not going to do anything. That's not going to do anything. It just doesn't make sense. It's the same as if you're shaking a pot, except I would have to pick up the coffee pot, swirl it once or twice, and put it down. It doesn't get clean like that. You got to really shake it for it to work. It's not like you don't just put ice in a coffee pot and then just go like that and it's clean. No, I don't think he has a shelf. Yes, but they don't use salt. They didn't say salt. They said the ice and the gel. That does not. Okay, I would believe you it's an abrasive, but for an abrasive to work, the abrasive has to you know what I mean? It has to you have to rub the abrasive on there. You can't just wipe an abrasive on something and then it goes away. You can't shake a toilet. So, I don't know. Yeah, okay, salt keeps it from melting. I hear you. I understand you. But that doesn't help you clean the walls of a toilet. None of that I'm missing. People are trying to type, and YouTube's not letting them, and then I'm not seeing all the comments. So we are having one half of a conversation right now. You use toilet. I've shaken a few toilets myself. Okay, you use the brush. Got it. To swirl it. But the brush is not putting the ice anywhere near the wall. It's doing the opposite. It's pushing it away. The salt sticks to the ice. The salt is pushed away. The salt that's not stuck to the ice is melted in the toilet. Not abrasive at all anymore. So, yeah, I'm on live chat. It's just, if you put salt on the ice, okay, the salt makes the ice colder, and the salt sticks to the ice. That's how it cleans the coffee pot. The ice is stuck to the salt. The ice is heavy enough that it scrapes the salt against the side of the coffee pot. That can't happen in a toilet. Even if you use a brush, the brush will hit the wall, but not the ice. And the ice, there's so much water in the toilet. The salt does not stick to the ice and make it abrasive. The salt just melts. The ice starts to melt. The gel always, even with a whole bunch of ice in there, does not stay a gel. Oh, I understand that. You use a lot of ice to fill the toilet. Still too much water in there. You have to remove so much water in there for that to be abrasive at all. Like, it's just, go ahead and put an ice tray in your toilet right now. Put salt on it. Then reach in and grab one of those ice cubes. The salt is not on there anymore. It's melted. The ice is melted. The ice is not hitting the side of the toilet. The ice is not scratching it. You would really have to fill that sucker up with ice, and you would have to dump a lot of freaking salt in there to overcome all that water. It's just physics. I mean, it's just physics. Oh no, Anna. Get out of the hospital. Yeah, we did mess up. We have 3 minutes and 38 seconds of court left, and we're gonna press play. I'm going to continue scrubbing my toilets the way I always do with a cat. If you put a cat in and shut the lid, that's abrasive. Way abrasive. Cleans every inch. Don't do that. Don't throw your cat in the toilet. Don't do that.
And you're being held on a $1,000 cash bond. I'm going to modify that today and have you released to what we call pretrial supervision. Okay. So you get released on your own recognizance today. But you are to check in with our probation department, and they will start you on what's called pretrial services. And you're going to be on those pretrial services on the following terms and conditions. To report to that office immediately upon your release. You're not to violate the law, appear at all future court hearings, abstain from the use.
Neither is throwing up inside my purse, Eileen. That's not funny either.
For possession of alcohol or controlled substances unless prescribed to you, and complete a substance abuse assessment and follow all recommendations and authorize release of information to probation and the court.
Okay. Could you repeat the first part of that?
Yeah, I will actually. I'll send you an order down to the jail. They will give to you before your release.
Okay.
So you have that all in writing?
I absolutely know. I wasn't intoxicated either. So I'm over here like probationary kind of things. I'm almost like, but I accept it. You know what I mean?
It's a term of the release. Instead of posting a cash bond, that's what I'm going to release you to, saying
cool.
You do get to be out of jail, but it's under certain conditions while this is pending.
Cool. Yeah, I was literally just exercising.
Okay.
Am I able to tell you, or are you just in a rush?
So no, I'm not in a rush. But the purpose of today's hearing is to just advise.
Clearly, sir, we don't tell stories on this channel. You need to shut up and keep it on topic.
Advise you your rights and the allegations against you. Going forward, since you're not represented, you can reach out to the prosecutor's office after your release and attempt to discuss that with them. You don't have to. You have all your Fifth Amendment rights. You don't have to talk to them about anything, but you certainly can. But we will send that order down to the jail with the terms of that release.
And while we're at it, while I'm
Yes,
on,
sir.
if you don't mind, I would like to tell just a story of what I feel happened, if it's okay, off record. Maybe.
Well, so I'm not. We're not going to hear that today. That's what we would eventually have a trial for if it gets to that point. But I will order release today, subject to these terms.
Yeah. Yes. And can you repeat what that you were talking exactly what you're saying? You're putting me on. Can you repeat? Probably.
Yes, pretrial supervision.
Pretrial supervision.
This is.
But you will receive a copy of that order prior to.
That should be
your
my
release
new
from the jail.
description.
And I need to talk to the
Probation.
So of the.
Yeah, if you're walking, it's. I don't know the distance. Just straight up Whitlock Avenue. Take a right on Binford, and you're there.
Okay, so there's going to be like a probation office. I can Google.
Yes.
Okay, perfect. Probation office.
I bet he had the cutest little curly hair when he was a little boy.
Right.
Think of
And
him at
that's-
like 4. Oh man.
Yeah,
That's going to be. We'll enter that plea of not guilty, and we'll see you back here on May 4th at 9 a.m.
Awesome. May 4th at 9 a.m. Thank you so much,
Yes,
Your
sir.
Honor.
You'll be getting probably processed out in the next half hour or so.
What was your last name again?
Petrie.
Petrie or Beatrie? Like a P or a B?
Petrie, as in like Petri dish.
That's awesome. Thank you, Your Honor, Petrie, and have a wonderful rest of your day.
You do the same.
Thank you.
Not a last name I want. Petrie. No, I do not want that. I do not. All right, guys, we made it to the end. We took a few side roads, but that's okay. I shall see you all in Bill's court, if I'm still awake, or I'll see you tomorrow, Wednesday. 2 streams tomorrow. Whew. Go drink some vitamin C. Hi, nurse. Hello, nurse. Anna, tell your nurse we asked about her. Him? I shouldn't assume. Bye, guys. Thank you.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright, she's got that grace. Come join the fun, it's a welcome and play. I can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her style is classy, she's always top shelf. Don't take my word, come and see for yourself. Her cases are new with a twist or two. I really like them, I believe you will too. A little lifeline passed along in rhyme. Why don't you join us? It's a guaranteed good time.